Hello students, today we are going to discuss the judicial control over administrative discretion of administrative authorities. First of all, let us see the meaning of discretion. Discretion in layman's language means choosing from amongst the various available alternatives without reference to any predetermined criteria, no matter how fanciful that choice may be. A person writing his will has such discretion to dispose of his property in any manner, no matter how arbitrary or fanciful it may be. But the term discretion, when qualified by the word administrative, has somewhat different overtones. Discretion in this sense means choosing from amongst the various available alternatives, but with reference to the rules of reason and justice and not according to personal whims. Such exercise is not to be arbitrary, vague and fanciful, but legal and regular. The problem of administrative discretion is complex. It is true that in any intensive form of government, the government cannot function without the exercise of some discretion by the officials. It is necessary not only for the individualization of the administrative power, but also because it is humanly impossible to lay down a rule for every conceivable eventually in the complex art of modern government. But it is equally true that absolute discretion is ruthless master. It is more destructive of freedom than any of man's other inventions. Therefore, there has been a constant conflict between the claims of the administration to an absolute discretion and the claims of subjects to a reasonable exercise of it. Discretionary power by itself is not pure evil, but gives much room for misuse. Therefore, remedy lies in tightening the procedure and not in abolishing the power itself. Now, let us talk about the judicial behavior and administrative discretion in India. Though courts in India have developed a few effective parameters for the proper exercise of discretion, the conspectus of judicial behavior still remains halting, variegated and residual, and lacks the activism of the American courts. Now, let us see the stages of judicial control over administrative discretion. Judicial control mechanism of administrative discretion is exercised at two stages: control at the stage of delegation of discretion, control at the stage of the exercise of discretion. Coming to the first point, control at the stage of delegation of discretion, the court exercises control over delegation of discretionary powers to the administration by adjudicating upon the constitutionality of the law under which such powers are delegated with reference to the fundamental rights enunciated in part 3 of the Indian Constitution. Therefore, if the law confers vague and wide discretionary power on any administrative authority, it may be declared ultra vires Article 14 and Article 19 and other provisions of the Constitution. In case of delegated legislation, the courts have, after been satisfied with vague or broad statements of policy, but usually it has not been so in cases of application of fundamental rights to statutes conferring administrative discretion. The reason is that delegated legislation, being a power to make an order of general applicability, presents less chance of administrative arbitrariness than administrative discretion, which applies from case to case. Second stage of judicial control is at the stage of exercise of discretion. In India, unlike the USA, there is no Administrative Procedure Act providing for judicial review on the exercise of administrative discretion. Therefore, the power of judicial review arises from the constitutional configuration of courts. Courts in India have always held the view that judge proof discretion is a negation of rule of law. Therefore, they have developed various formulations to control the exercise of administrative discretion. These formulations may be conveniently grouped into two broad generalizations. First, that the authority is deemed not to have exercised its discretion at all, or failure to exercise discretion, that is non application of mind. Second one is that the authority has not exercised its discretion properly, or excess or abuse of discretion. Now, let us discuss these formulations one by one. First one is that the authority is deemed not to have exercised its discretion at all, that is non application of mind. Under this categorization, courts exercise judicial control over administrative discretion if the authority has either abdicated its power or has put fetters on its exercise or the jurisdictional facts are either non-existent or have been wrongly determined. The authority in which discretion is vested can be compelled to exercise it, but not to exercise it in a particular manner. When a discretionary power is conferred on an authority, the said authority must exercise that power after applying its mind to the fact and circumstances of the case in hand. Thus, where the authority abdicates its power, that is abdication of functions, acting under dictation, conditional precedents, acts mechanically and without due care, imposes fetters on the exercise of discretion, there is a failure to exercise discretion. And second formula is that the authority has not exercised its discretion properly, that is abuse of discretion. This is an all embracing formulation developed by courts in India to control the exercise of discretion by administrative authority. When discretionary power is conferred on administrative authority, it must be exercised according to law. When the mode of exercising a valid power is improper or unreasonable, there is an abuse of the power. Improper exercise of discretion includes everything which English courts includes in unreasonable exercise of discretion and American courts include in arbitrary and capricious exercise of discretion. Improper exercise of discretion includes such things as taking in irrelevant considerations into account, acting for improper purpose, asking wrong questions, acting in bad faith, neglecting to take into consideration relevant factors and acting unreasonably, etc. With this, I would like to conclude this session. We shall see more of it in the upcoming classes. Thank you.